We cannot begin understanding how judges make decisions without understanding the concept of stare decisis. So let's start off with that so you can understand what that concept is. The American Bar Association defines the term as follows. Stare decisis, a Latin term that means let the decision stand, or to stand by things already decided. This is a foundational concept in the American legal system. To put it simply, stare decisis holds that courts and judges should honor precedent, or the decisions and rulings and opinions prior cases. See, that's the definition. So now we understand it said we're going to follow. This is what judges say. Listen, that one, I may not like how that decision came out, but that is the law, and I'm going to follow the law until the legislature changes the law. I'm not going to say, I don't like that law, therefore I'm going to apply my own law. Now, stare decisis has been bounced around by both conservative and liberal judges. Both progressive judges and originalist judges, that's a term for a conservative originalist judge, have used stare decisis to support their decisions or have ignored stare decisis when they needed to. The concept is not constitutionally mandated. Judicial construction, that is a term of how judges make decisions, judicial construction, is a way of describing how judges form their opinions as to what is important within the language of the Constitution. What this means is different for each judge, and the concept has been interpreted differently over the years. For the reasons stated above, stare decisis is very important for the stability of the law, the credibility of the law, and democracy. However, times do change, and what is considered normal in one age might be considered inappropriate in another age. Most judges will state to you that they are not elected to make law. That is true. And on the hundreds of candidates for the judges, and never once did I have a judge tell me, I'm here to make law. But rather, they're here to interpret the law. However, when they overstep old law or precedents, that is what they are doing in effect. So when they write new law over existing understandings of the law, they basically are creating new law. My attempt with these classes is to explain how judges reach their decisions using the available matrix before the court. And by matrix, I mean the cases they've had before them. I believe that even if you don't agree with the reasoning of the decision, if it is understandable, it is clear, the reasoning, then your faith in the system can be maintained. It is when the legislature makes controversial decisions, which of course are political, and the court ignores established norms, what we call jurisprudence, then the combination is a combustible mix for social explosion. Democracy is not guaranteed system, even in the United States. Our generation, as have past generations, have witnessed the result of citizens losing faith and willing to go to war or resolved to use violence to correct injustice that they perceived. These lectures is an attempt to soothe the intellectual assault for those willing to take some time to digest the decision-making process of the courts. So, what does the First Amendment actually say? It says the following. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably to assemble and to petition the government for redress of their grievances. Unquote. These few simple words have caused thousands of cases to be filed in federal and state courts throughout our history, and have perplexed politicians, citizens, and judges trying to decipher the meaning of this simple paragraph. These lectures are designed to assist persons of faith to understand the limitations that the law imposes on their ability to practice their faith as they see fit, to examine the government's limitation in passing laws that might force some in society to conform to their behavior and what others in religious majorities believe as an appropriate social standard. So there's two standards, right? We don't want to impose our religion on others, nor can someone stop me from practicing my religion. Now those are the tough questions, and that's why we're going to be looking at case by case as we go through the lessons. We will explore the delicate balance that the United States Supreme Court, often I'll call it SCOTUS, the United States Supreme Court, has to weigh on each and every case placed before it when determining the fine line between the Establishment Clause and the Prohibition of Free Exercise Clause of this essential amendment. Those are the two clauses within the First Amendment that we will be talking about in the coming lessons. The Establishment Clause, you cannot establish a religion, and prohibiting the Free Exercise Clause, which means the government may not prohibit you from practicing your religion. It is my goal to educate faith leaders as well as political and community leaders, both of whom are passionate and fervent believers in their respective social values. There is another way to understand the reach of the rights under the First Amendment and the rights of a pluralistic society, such as that in the United States. There is much literature and case law already established in the body of law known as religious rights or religious freedom law. There are entire courses in all our American law schools addressing the theme, as well as voluminous textbooks on the subject matter, with thousands of cases attempting to explain the nuances of the law. It is not my intent to write this book for lawyers, but for the layperson grappling with the complexity of the law and the sensitivity of the topic within the society in which we live. My thought is to take various contemporary cases facing our nation that have made it to the headlines of our newspapers and media outlets. I will explain their origins and the competing interests of the parties. You may actually sympathize with neither party, but we will explore the conflicts that the facts bring forth and how the First Amendment was or could have been interpreted. When necessary, I may resort to old case law, which may have set the mark or precedent in the legal jargon for the decision the court ultimately made. However, I will strive to make reading relevant and understandable without resorting to Latin terms so often used in legal writing. As a former legislator, law school professor, and a licensed faith leader, I will provide an analysis of the various positions of the parties in the litigation and present the issues in a manner that the reader can reach their own conclusions after weighing the facts and the law. So what is the Free Exercise Clause and the Establishment Clause? I have chosen various stories from current events that cause a clash and thus a lot of consternation and litigation by citizens of the states. These stories exemplify the type and tenor of the controversies facing persons of faith and those committed to the separation of church and state. It would be an error to conclude that those advocating separation of church and state are atheists or anti-religious individuals. Actually, many persons of faith believe that it is essential for the freedom of religious rights that the government must not interfere nor attempt to regulate any issue of faith in favor of any religious doctrine. James Madison, our fifth president and one of the founders and authors of the Constitution, wrote, he was the fourth president, and one of the architects, he was an architect of the Constitution, wrote that following the debate on the Bill of Rights before the Virginia House of Representatives, that would have provided a government stipend for teachers of the Christian religion. I indicated to you previously that some states had actually official religions and the ministers on their payroll. But he wrote, because we hold it for a fundamental and inalienable truth that religion or the duty we owe to our Creator and the manner of discharging it can be directed only by reason and conviction, not by force or violence. The religion of every man must be left to the conviction and conscience of every man, and it is the right of every man to exercise these as he may dictate. This right is an unalienable right. It is unalienable because the opinions of a man, depending only on the evidence contemplated by their own minds, cannot follow the dictates of other men. It is unalienable also because what is here a right toward men is a duty toward the Creator. It is a duty of every man to render the Creator such homage and such only as he believes is acceptable to him. This duty is precedent, both in order and in time and degree, to the claims of civil society, wrote James Madison. Thus, men very much committed to the worship and homage of the Creator, God, would insist that the government had no place in maintaining or supporting one religious doctrine over another. To protect the freedom of man to worship as he felt was an unalienable right and not subject to legislative fiat. It is also true that over time, partisan politics has framed the religious freedom as questions as freedom from religion. Many of the early cases in controversy were brought by religious minorities or atheists who felt that the First Amendment not only dealt with the Establishment Clause, they were fighting for the rights of minority religions or those who had no desire to follow religious commandments of the majority faiths. This was understandable. However, more recent cases are looking at religious rights through the lens of the prohibit the free exercise clause as a way to preserve religious preferences from secular legislatures. So what I'm trying to tell you is that these two clauses often clash because some people want to use the law to establish a certain right. For example, one of the earliest cases had to establish Sunday as the day of the Sabbath. So there was a point in our history when you could not open a business on Sundays. Why? Because that was a religious point of view, and they were the majority, those Christians that had the Sabbath on Sunday. Until someone who observes the Sabbath on a Saturday brought a lawsuit and said, why are you forcing me to close my business on Sunday when I don't believe that? And I believe Saturday is the day of the Sabbath. And because the law closing the businesses on Sunday was based to establish a religious faith or religious form, the court struck that down. That's a simple example. It gets much more complicated later on. What needs to be understood is that the modern attitudes about religion and religious rights do not compare to the attitudes of the 18th and 19th centuries. These early societies assumed natural Christian values and thought it appropriate to legislate morality. Something as simple as legislating the all commerce must cease on the Sabbath, which I just mentioned, was considered natural and not an establishment of any religious practice. Of course, if you were a Seventh-day Adventist or a practitioner of Judaism, you would disagree and be required to bring a lawsuit to change the law. Thus, the early cases of religious rights concentrated on the minority faiths and those of no faith litigating or being forced religious practices or exclusion of minority rights. Eventually, legislators took the First Amendment to mean that no law that implies or evokes a religious practice could pass constitutional muster. However, those who believed that they had the right to their religious beliefs started to challenge these neutral laws as being in violation of their right because it prohibits their free exercise of their religion. The First Amendment has that natural tension between these two clauses, and this is what we will attempt to explore in these lectures. Each generation brings its challenges and needs for society. The courts are the last resort when interest groups cannot reach an accommodation on what is acceptable legislation and what is considered an infringement or establishment of someone else's mores. This area of law is vast and will not be resolved by this series, my book, or any paper, but only with the understanding of the basics of the First Amendment and the application of its principles as is established in our tradition, accompanied with a willingness to truly believe in those principles as strongly as they do in their theology.